Hello, my name's Chris Burns. I'm a partner and head of the family team here at Lupton Fawcett. Today I thought it would be helpful to run through with you some of the key issues that we talk to clients about when there's a family business involved, especially in a divorce scenario. When there's a family business involved in a divorce scenario, the first thing we'd have to do normally is to identify the structure of the business. Traditionally, these tend to be either limited companies or partnerships. There are some key differences between those two different legal structures. A limited company is a separate legal entity. The shareholders do not have any interest in the company. So the first thing we need to do is ascertain who are the shareholders and who are the officers and directors of the company. The other entity that we often come across is a traditional partnership. Where there's a partnership involved, we need to be clear who the partners in the business are. Unlike a limited company, a partnership does not have a separate legal entity. We need to be clear who the partners in the business are. What are the terms of the partnership deed? As your trusted advisor, it's important that we have an understanding of the type of business that you operate and the markets your business operates in. It's important, from our perspective, to get a clear understanding of your business. What does your business do? How would you describe your business? To help us get a real understanding of your business and the financial structure of your business, we will want to talk to you and run through with you your accounts. We'll want to look at your most recent audited accounts. We'll want to have a look at your management accounts. We'll want to understand the prospects of the business in the future and how the business might operate. What benefits have you and the other party derived from the business during the life of the marriage? And is there any prospect of a potential sale of the company, and who might be interested in purchasing the shares of the business? Having got a clear understanding of you and your business, we then need to talk about some of the key issues that ordinarily arise when looking at a family business in the context of a divorce scenario. We'll talk to you about things relating to your business. Is there a market for the shares of your business or the assets of the business? We will need to consider with you whether there's to be a sale of shares or assets of the business, and what's the best way to go about dealing with those in a divorce scenario. It's important that we consider how your business should be valued. If there is to be a transfer of shares, then consideration needs to be given as to the value of those shares. How will the money be raised to deal with transfer of shares? Is the money to be raised within the business or outside the business? If it's to be raised in the business, what impact is that going to have on the business and the future trading of the business? One other matter that we need to consider is whether there are any directors' loan accounts and how those might be dealt with as part of an overall divorce scenario. If there's a prospect of your spouse acquiring some shares in the business, then we need to consider whether there are any restrictions upon that spouse acquiring an interest in the business. The first port of call would be to look at the Articles of Association and the shareholders' agreement. Often there are what are called preemption rights, where if there are to be a transfer of shares, those need to be transferred to existing directors or shareholders in the business. It may be that some of the other directors in the business will refuse to register a transfer of shares to a third party. That's a very important consideration, because if there is such a restriction in the Articles of Association, then it's an absolute restriction as long as the director is acting in the best interests of the company, and the refusal of the director to register the transfer of shares is bona fide. A final consideration here is whether there's to be a disclosure of shareholders' agreements. It may well be that some of your co-shareholders do not agree to disclosure of the shareholders' agreement, and there may be issues of confidentiality to consider there. So when we're looking at a family business in a divorce scenario, one of the key issues is the value of the business. If there has to be an expert valuation of the business, a court will only permit such a valuation if it is necessary. That is the legal test. It has to be necessary to assist the court in resolving the proceedings. In most cases, the court will only require a current valuation of the business. However, if the business is a long-standing one, which was in existence prior to the marriage, then it may be that the court or one of the parties would wish to have a valuation of the business at the time of incorporation of the business, but the assets will always be valued at the date of the final hearing. Having considered the value of your family business, another key issue that needs to be looked at is what costs of realisation there might be of realising an interest in the business. We will look with you as to whether there is a minority shareholding, because if a party holds less than 100% of the shares, then the court will need to consider whether there should be a discount applied because there is a minority shareholding in place. Where there is a discount to be applied for a minority shareholding, the extent of that needs to be considered and again valued. It may be that accountancy advice is required to assist with that process. Tax is another key issue that we need to look at with you. Again, in terms of the cost of realisation, there may well be tax issues, and again we will guide you through that and take expert accountancy advice to assist you with tax matters as necessary. Finally, you should give consideration to whether you're able to claim entrepreneur's relief. If that's available, that may reduce down any capital gains tax to 10%, so it's an important matter to run through with you. And again, if necessary, we will guide you through that process and get independent accountancy advice if necessary. So where there is a family business involved in divorce, all of these matters and key issues are things that we will run through with you in some detail. Where there is a family business involved in a divorce scenario, the family business, like any other asset, will be considered by the court. The court needs to look at the family business and distribute that together with the other assets to achieve fairness to both parties. In many of the divorce cases that we see, often the family business is the key asset of the marriage. It's therefore important that clients get independent, expert legal advice at the earliest opportunity to ensure that all of the matters which I've just talked to you about are looked at carefully and considered cautiously within a divorce scenario. We have a range of information guides on our website. Please visit luptonfawcett.law.